The article that you refer to, that is Article 137, that a person qualifies for nomination as a presidential candidate if the person is a citizen by birth, Kalonzo is qualified to stand for election as a member of parliament, I believe he is, is nominated by a political party or is an independent candidate, and is nominated by not fewer than 2,000 voters from each of the majority of the counties. And so, Wakili, then, if that is the case, and this is the constitution, how do you then reconcile what the Political Parties Act says and what the agreement for these political parties in forming a coalition political party provide?
Well, in my view, we don't even need to reconcile or harmonize. We just need to read it in together with other laws, The Constitution provides the framework upon which the details are fleshed out in statutes, In my reading of electoral laws, that is the condition that a presidential candidate must meet among other conditions outlined in the statute. I think it would turn logic on its head that a substantive statute, like the Political Parties Act as amended, should provide for provisions on coalition of, on formation of coalitions and a coalition party, and that political parties should sign into that arrangement either as a coalition party or members of a coalition, and then not have that law bind the primary parties who have signed onto it. It would be very difficult to persuade a judge to ignore the Political Parties Amendment Act, the political parties as amended. But I think it's a matter that is open to interpretation and conversation. What is undeniable is this. Kalonzo's chances of running for president now hangs in the balance, partly because of his indecisiveness. Because you see, both arguments are cogent, You may want to rely on the Constitution to say, well, I mean, this is the superior law, let's stick to it. The alternate argument is quite cogent as well, Because it says the Constitution must be read together with all other electoral laws. And those laws must be given the meaning the lawmaker intended them to have. And the parties that signed into that agreement, surely it must have some legal consequences. And what Kalonzo is looking at now, there is a very high possibility, let me now just put it that way, there's a very high possibility that is not going to be cleared. But I think what we must do, and I agree with Commissioner, we must permit IEBC as the election manager to interpret the law as they know it. As you can see now, the two lawyers have different approaches to this,
Right.
What we must not do is to bastardize IEBC's decision-making process, the independence, including the interpretation of what Kalonzo's candidature now means. If someone is not satisfied with IEBC's interpretive approach regarding the candidature of His Excellency, the Vice President, former Vice President Kalonzo Musyoka, then the default position, Sam, would be that you move to court to have a final opinion, because that's where we all go for final interpretation. All of us are bound to interpret the Constitution one way or another.
Right.
Kalonzo, if he thinks, having signed the agreement, he's still persuaded that he needs to run, fine, he can try his luck. If IEBC is not persuaded, IEBC will not clear him. If IEBC is of the view, adopted by Commissioner, that, they can clear him, then it now turns on a public-spirited citizen or a member of the coalition party to urgently move to court to question the legality or even the constitutionality of Kalonzo's candidature. And I think the matter will be settled.
And he said on Monday, he said that he still has unfinished business with the Political Parties Act as amended. At this point in time, with just about 6 or so days to the start of clearance by IEBC, are there any useful or meaningful orders you can get that will suspend the implementation of the Political Parties Act as amended, especially on formation of a coalition political party?
I think you'll be surprised. Courts are working overtime. And I'm sure even this week, there's a matter we're arguing today, relating to the two-third gender principle, whether parties should comply or not. Definitely, the judge knows that a judgment must be rendered in the course of the week, because official campaigns begin, I think, on Sunday. And therefore, yes, these are questions and that is the problem. The only problem I see is this in our electoral process. And we have discussed this. And IEBC said, let us manage our politics and lawmaking process in advance to allow them to prepare. Don't push them to a position where you interfere with election planning. and management. But our people, we don't listen. Our politics is politics of convenience, and now when there's a stalemate that requires judicial interpretation, judges also are cornered because somebody must move to court urgently to get a final determination either way. If IEBC decides not to clear Kalonzo, and that I would support that reading of the law, Kalonzo might move to court and the court must pronounce itself. If IEBC clears Kalonzo, somebody within the coalition party would move to court to seek interpretation.
Right.
I think we push things so late into the deadline that we inconvenience the election manager, we inconvenience judicial officers, and then we antagonize the entire electoral process. I think that is a lesson we have not learned since 2017.